For family farms, one of the biggest challenges isn't just the hard work. It's ensuring that the legacy you've built over decades can survive beyond you. Today, we're diving into a real-life case study to explore this very issue. While we've changed the names for privacy reasons, this story is based upon a real client scenario. Meet Ken and Sandy. They own 400 acres in Darke County, Ohio, and have 3 adult children. One of them, Robert, dreams of taking over the farm. But how can they transition everything to him fairly without neglecting their daughters? And how do they secure their own financial future while keeping the farm in the family? Without the right plan in place, Ken and Sandy could jeopardize not only their retirement, but also the stability of their family legacy. It's a scenario that plays out far too often. Family farms sold or divided, and the hard work of generations lost. Balancing family expectations, financial needs, and tax implications is no small task, and the stress can be overwhelming. In this video, we'll walk you through Ken and Sandy's story step by step, breaking down the strategies they can use to transition the farm to their son Robert to ensure a fair inheritance for their daughters and secure their own retirement. If you're facing a similar situation, stay tuned. You'll gain actionable insight to protect your family farm and make this complex transition smoother for everyone involved. Now let's talk about some background. Ken and Sandy live in Darke County, Ohio. They own a farm with approximately 400 acres of ground, of which most is tillable. They lease another 800 acres that they regularly farm. Ken works full-time on the farm. Sandy works part-time driving a school bus. One of the reasons why Sandy likes driving the school bus, it does provide health insurance for the family. That's a really nice added benefit. Of the 3 adult children, Robert works full-time in town, but he spends a lot of time on the weekends and in the evening helping his dad out on the farm. The 2 adult daughters are both married and are beginning to build their own family, but neither of their spouses are engaged in any farming activity, nor are the daughters. Let's talk a little bit about Ken and Sandy's current estate planning situation and their financial situation. Ken and Sandy have been very frugal. They have no debt to speak of. In addition to not having any debt, Ken had the foresight to set up a SEP IRA, and it has been funded every single year. In addition to the SEP IRA, they have managed to squirrel away about $500,000 in a brokerage account. In addition to the SEP IRA and the brokerage account, they run everything out of a joint family bank account. They do have a separate farm account to pay for all of the farm expenses and to receive all of the farm income. That separate account is in Ken's name, while the family account is in their joint name. Long term, Robert would like to take over the farm. At least he thinks so at this point in time. Ken and Sandy, early on, soon after their first child was born, developed what I call sweetheart wills. Those wills simply are 2 pages long. They name each other as the beneficiary, and when the second one of them dies, or if their spouse is not alive, the 3 children inherit equally. Because they set these up many years ago, the wills named Ken's brother as the executor and Sandy's sister as the backup executor of the will. Their healthcare power of attorney and financial power of attorney were also done many years ago. They're over 20 years old, as is their will. They do have a living will, which says that if they're ever determined to be permanently unconscious, all extraordinary measures can be terminated. So that's pretty well the situation that Ken and Sandy find themselves in. One additional fact that I ought to mention is that all 3 kids live in the vicinity of the farm. So it's a very close-knit family, and they communicate with each other on a regular basis. And for them, like many of my clients, there are no real significant issues at this point in time with respect to any of the kids. They're fortunate in that regard. They do anticipate that each one of their kids will have children, so their expectation is that they will have some grandchildren coming along the way. In terms of the future of the farm, Ken is thinking that he will want to work the farm up until the age of 70. He's currently 59, Sandy's 58. So He's thinking another 11 years up until age 70. He thinks that in retirement, the two of them will need about $50,000 per year. Again, they live fairly conservatively, but they would like to perhaps buy a new car and do some travel in retirement. That's kind of an important aspect of what they need to do. In terms of their planning so far, they don't have any life insurance. They don't have any long-term care insurance. They do work with a local CPA. They meet with him every year in the fall. And the basic practice has been overall effort to zero out the income tax every year. What Ken does is he meets with the CPA, finds out, has him do a projection of how much income tax they're going to owe if they've had a good year. And then he'll go out and buy a piece of equipment and use either accelerated depreciation or bonus depreciation to, in essence, write off everything. In terms of the farm itself, there are no entities that have been created. They've been a little reluctant to go talk to a lawyer about creating any entities. So there are no corporations, no limited liability companies, nor are there any partnerships or anything like that. They have been successful in minimizing their taxes between being able to make contributions to the SEP IRA and to buy equipment. They paid very little in income tax so far. When Ken and Sandy discuss their overall planning goals, their number one concern is to make sure that their three children, Robert, Sylvia, and Teresa, can live in peace and harmony and never have a dispute over the farm. Yet they want to make sure that the kids are treated fairly. Whether it be equal or not, that's, they understand, an important conversation they need to have. But they want to make sure that there is no dispute. That's their number one goal. They want to make sure that if they end up needing long-term care in their old age, that they have that taken care of. They're not exactly sure how to go about that, but they know that they need to address that. Also, they want to make sure that if they do pass away and Robert inherits the farm, that he simply can't sell it and profit from a quick sale soon after they pass away and not share the proceeds with any of the daughters. So when we hear what those goals are, our primary interest is making sure that we get a basic plan in place that will accomplish some of the following goals. Number one, in the event of Ken or Sandy becoming incapacitated, we want to make sure that they avoid living probate. That is, a guardianship. We want to make sure that if one of them dies, whenever that may be, that it avoids the death probate process. You know, that death probate process is unnecessary. Oftentimes it takes up to 2 years to go through. It can cost as much as 5 to 8% of an estate, and it's totally unnecessary, and ultimately it puts the probate court in control. So we want to avoid both living and death probate, number one. Number two, we want to make sure that during Ken and Sandy's lifetime, we continue to minimize the amount of taxes that we're going to owe. That's important. We want to keep an eye on the estate tax, but as of now, we understand that because the exemption amount in 2024 and 2025 will exceed over $28 million, that is currently not an issue. Having said that, we're well aware that there are efforts underway to maybe reduce that long term. So we have to at least keep our eye on that. But right now, the estate tax is not a major issue for them. But saving income taxes is, and making sure that we preserve the step up in tax basis when Ken and Sandy pass away. If the farm is going down to their son, Robert, they want to make sure that Robert gets a step up in basis. Now, we have to decide whether we want to step up one half when Ken dies and the other half when Sandy dies. You know, most couples recognize that it's probable that a surviving spouse on average lives an additional 10 years. So do we want to step up one half when each dies, or do we want a full step up when the first dies, or do we want a full step up when the second one dies? And that's a critical inquiry that we're going to have to talk about. Thirdly, we want to make sure that we have some creditor protection. You know, the farm operation is a dangerous occupation. It's always conceivable that there might be some lawsuit if somebody gets hurt or injured, whether it be a farm accident or whether Ken and Sandy are on vacation and they drive down the road going too fast and hit a school bus and hurt several people and get sued. We want to make sure they can't take the 400 acres. We want to make sure they can't take the $500,000 in the brokerage account. We want to make sure that they can't take their house. So how do we do asset protection for both farm accidents and personal assets? Well, we have to talk about that. In addition to that, we have to make sure, as I mentioned, that we're able to secure their long-term care. How do we do that? Well, there's only a couple ways. We either got to insure the risk through what I call asset-based long-term care if we're healthy enough to get it, or two, we got to plan for Medicaid. It's going to be one or the other for most of our clients. Lastly, we have a unique opportunity here to make sure we get a proper transfer plan put in place. And once we decide what's going to be transferred to the 3 children, that whatever they're going to get, we want to make sure they get it in a way where it is protected in case something bad happens to them. So what are the kind of the bad things that happen to our kids? Well, at the end of the day, they can get divorced. We got a 60% divorce rate going. They could get in a car accident themselves and get sued. They could go bankrupt. They could themselves become disabled, or they could die. And if they die under most estate plans, their inheritance will go to their spouse, not to the grandkids. What Ken and Sandy have indicated to us is that their desire, as much as they love their in-laws, their desire is to see anything passed along to their grandchildren. That's part of this family legacy. So that kind of gives us the overview. If we're going to try to accomplish all of those goals in one setting, what does that look like? Well, let's take a look here. If I do something for Ken and Sandy, the first thing that I want to make sure I do on the farm side is I want to have a LLC that is an operating company. And that operating company will receive all of the farm income and will pay all of the bills, but it won't own any of the land. Secondarily, I want to create a second LLC, and I like to call it a holding company LLC. And this holding company LLC will own the land. Now, there is a master lease agreement between these 2 entities, and it's real critical that it be a written, detailed agreement between the 2 entities. What will happen is if there's a farm accident, the operating company will be exposed. So whatever the operating company owns, typically that operating company is going to have a bank account. It might have some grain on hand. It might even have some cattle or hogs. Those assets are always going to be exposed to the farm operation. On the other hand, the holding company is going to have the land. And we'll have to have a conversation about how we want to handle the equipment. There's not a hard and fast way for equipment to be handled. In this case, Ken indicated that he so far has invested about $1.2 million in equipment. So it's a sizable amount. So we may want to protect some of that from a potential creditor or lawsuit. What are our options? Well, one option is have it owned by the operating company. But if we do that, it'll be exposed to farm accidents. Another option is to create a separate equipment LLC and pay rent for it. A little more risky if we put it in the holding company and have it own the equipment, but it is possible. But we have to make sure we make the rental payments for the equipment on an annual basis by doing a master lease agreement. So this lease agreement becomes really critical, and it becomes really important that these 2 make sure that that we pay the rent between these 2 entities. So how those entities are taxed is a critical question. One option we have under the tax law is for them to be disregarded entities and place them 100% in Ken's name. The other possibility is we put them 50-50 between Ken and Sandy and do a partnership. There are some advantages to partnership taxation. Another option is to put the operating company as an S corporation to try to save some self-employment taxes, but keep the holding company either as a sole proprietor or as a partnership. Also, a few of my clients have requested through their CPA that the operating company be a C corporation because they want to be able to pay for health insurance, long-term care insurance, all through the company. And they want to build up a nest egg of retained earnings within the operating company rather than distributing it out on an annual basis. So figuring out how to tax these entities is a critical inquiry. In this case, Ken and Sandy decided that they would simply be single-member limited liability companies that would be disregarded for tax purposes, and that they were comfortable with that. Now, in terms of the other assets that they own, what we were going to do in this case was to create a revocable living trust that I'll designate as an RLT. And in this RLT, we're going to put their house and we're going to put their cars. We're going to put their tangible personal property. And we may put their brokerage account here. And these will all be retitled into the name of the revocable trust. Now, the next question that we have to ask is, where do we want the LLCs? Who do we want to own them? We certainly don't want Ken or Sandy to have individual ownership because that means it'll go through probate. So we either got to take these entities and transfer them into the revocable trust, which is an option, or if we're not able to get long-term care, we could create a Medicaid trust and place the two LLCs in the Medicaid trust. Now, what that means is 5 years after we do that, neither the operating company or the holding company will be accountable for purposes of determining Ken and Sandy's eligibility for Medicaid. If, on the other hand, we're able to have Ken and Sandy sit down with our long-term care advisors, we feel that they could fund a long-term care policy that will cover both of them, and they could get close to $750,000 worth of long-term care benefits by expending under $200,000. And so Ken and Sandy have expressed an interest in filing an application for asset-based long-term care because their primary goal is to be cared for at home or in assisted living. Now, if that's the case, Medicaid rarely will pay for at-home care or assisted living. They're going to have to privately pay for it. And if we're going to privately pay for it, even at their ages of 59 and 58, they can leverage a little bit of money that they have. They can leverage that. And at the end of the day, they're going to be able to get $750,000 worth of long-term care for under $200,000, and we like that idea. Now, if they get long-term care, we probably don't need a Medicaid trust. So one option we have is to take the two LLCs and have them owned by the revocable trust. Now, typically, Ken and Sandy are going to be the trustees of that revocable trust. In that trust, we're going to name each other as the successor trustee. Then the question becomes, who's going to fill in if both Ken and Sandy can't be a trustee? And in their case, what they've decided is that all three kids will be involved in serving as successor trustee. And I'm fine with having multiple children involved. This is a close-knit family. They haven't had any major disputes. All the kids seem to be stable and get along well. Now, another option that we've recently have been given under Ohio laws, rather than transferring it to a Medicaid trust or a revocable trust, and by the way, the revocable trust provides no additional creditor protection for the land. If we want additional protection, not only for the land, but also for the farm income, we can create an Ohio Legacy Trust. And Ken can create it and name Sandy as trustee, or Sandy can create it, name Ken trustee. And what we do is we transfer the two LLCs into the Legacy Trust. The beauty of that is that if Ken and Sandy get sued for a farm accident or a personal car accident, the entire farm operation, including all the land, is totally protected from any kind of creditor claim whatsoever, unless it is a creditor that is a secured creditor for the land. And in this case, they don't have any secured creditors because the land is paid off. They do have a line of credit that we will ultimately transfer from their individual names to the operating LLC names. That will occur. We'll get that operating line changed over. But in this case, once we transfer the operating company and holding company over to the Legacy Trust, then what happens is oftentimes as Ken and Sandy age, they may transfer more funds into the Legacy Trust to protect it. But here we're not going to do it at their age. There is a reason to keep some assets exposed. So here, at least in the initial design, we're going to put the house in the revocable trust. Under Ohio law, $250,000 worth of equity in the house will already be protected from any kind of creditor claim or lawsuit. Here, that will cover the bulk of the equity in the house. The only thing that's going to remain exposed will be their bank accounts as well as their brokerage account. By the way, there will be a need to have a checking account in both LLCs. Now, where do we go with respect to when they die? Well, if we want the farm operation to go to Robert, we're going to create a trust for Robert. Yeah, Ken and Sandy, as a part of their estate plan, will create a trust for Robert. And the existing LLCs will pass directly into that trust, either in part or in whole, depending upon the following scenario. In this case, what ended up happening is, as it pertains to Sylvia and Teresa, we set up a Sylvia trust and we set up a Teresa trust. And Ken and Sandy purchased a life insurance policy. And this life insurance policy that they purchased was $2 million. They wanted $1 million for each of the girls. Now, they recognize that 400 acres of ground is worth more than $1 million that they're giving to each of their daughters. But everybody in the family was comfortable with that arrangement, at least currently. Obviously, as things change, we can make a decision on what happens with some of the other assets. In this case, they initially decided that in addition to the $1 million life insurance that was going to go to Sylvia and Teresa, they would also put everything else that was in the revocable trust would go to Sylvia and Teresa. That included their house, their cars, and their brokerage account. One of the wild cards out here remains the IRA. And currently, that IRA will go to, it's Ken's IRA, it will go to Sandy, and then it will go equal shares to the 3 kids, because they want Robert, in addition to have the money that's in the farm account, they also know that he needs some cash to operate the business. So, by the time Ken passes, if we've got $600,000 in that IRA, they would like at least a third of that to go outright to Robert. So there you have it. Ken and Sandy's situation is not overly complicated, but here they are at 59 and 58. They have no plan in place. They understand pretty well what their goals are. They don't have any asset protection. They have not put together a succession plan or a transfer plan. This is not the only way to go about it. Let's say they're not insurable and they can't get the life insurance. Then the reality is Robert is going to have to purchase part of the farm operation from the other two, and there's going to have to be some set off for the other assets that Sylvia and Teresa get. Maybe in one case, maybe what we do is we give Robert half the farm as an inheritance, and he has to buy the other half out over time. Maybe at $7,500 an acre, maybe he's given 20 years to pay for it at the minimal interest rate. So those are some of the things that we can talk about. What's really important, though, is that we get this plan put in place and that we meet every year or two to go over it to make sure that as the family changes and as the law changes, this plan is flexible enough to adapt to those situations. So here we are. Ken and Sandy's story highlights that transitioning a family farm is about more than just passing down the land. It's about balancing legacy, fairness, and financial security to protect what matters most. Their journey shows how thoughtful planning can preserve a farm for future generations while addressing the needs of the entire family. But there's another critical piece to the puzzle: choosing the right business structure for your family farm. The structure you select can have a significant impact on taxes, liability, and your ability to achieve long-term goals. In the next video, we'll explore how to make the right choice for your farm. Click over now to learn more about your business structure.